C.D. Okafor.
Yes.
Most humbly appear for the appellants. Thank you, my lord.
Yes.
My lord, most respectfully,
Yes.
I am Kehinde Edu,
Yes.
appearing with O.V. Akowe and President Dibia.
Yes.
My lord, we are for the first respondent.
Yes.
My name is Chief Samson. With the kind permission, I'm holding the brief of IG Waru for the second respondent.
Yes. Judgment. A panel of 5 that consisted of Manana brothers John Ian Okoro JSC, Helen Moreau KG Ogumidu JSC, Tijani Abubakar JSC, Haruna Simon Samani JSC, and Mohammed Baba Idris JSC sat and had the appeal. The lead judgment was written by Manana brother John Ian Okoro JSC, and I read this judgment on his behalf. The appeal is against the judgment of the Court of Appeal, Abuja, holding at Abuja, in appeal number CA-ABJ-CV 2017-2024, delivered on the 17th day of January 2025, against the judgment of the Federal High Court in suit number FHC-ABJ-CS 1271-2024, commenced by the first respondent at the trial court, wherein the suit at the trial court was struck out for want of jurisdiction. The facts that led to the appeal has been captured in the body of the judgment. Having reviewed the arguments of counsel, the court unanimously agreed as follows. The court held inter alia that the court below, having found that the first respondent's main relief was relief number 5, which was predicated on the leadership of the first respondent and thus not justiciable, strayed beyond the jurisdiction into the realm where even angels dread to tread, to pronounce Barrister Julius Abure as the national chairman of the first respondent. Their lordships of the lower court were wrong to so do. The principles of law applicable here is as expressed in the Latin maxim that no one puts something on nothing and expects it to stand. The first respondent suit at the trial court had no legs to stand in the circumstances and deserves to be struck out. Permit us at this point to reiterate the tried position of the law that if a court of law is bereft of jurisdiction to attain the main relief in an action, it do not have the jurisdiction to attain the ancillary claim, and moreover, if the ancillary claim will inevitably involve a discussion of the main claim, as in this case, Situkur and Government of Gongola State. The 3 issues submitted for determination are hereby jointly resolved in favor of the appellants. In summary, both the trial court and the court below had no jurisdiction to entertain the suit of this first respondent, which main relief, as they both rightly observed, was inserted as relief number 5 as though it was an appendage. Consequent upon the foregoing, the decisions of both the trial court and the court below, recognizing Barrister Julius Abure as the national chairman of the first respondent, are hereby set aside. And suit number FHC ABJ CS 1271-2004 is hereby struck out for want of jurisdiction. In the same vein, the first respondent's cross appeal in appeal number SC CV 56A 2025, being an offshoot of the same judgment of the court below, is hereby dismissed. Before I'm done, may I admonish political parties and their members to endeavor to always allow their constitutions, rules, regulations, and guidelines to guide them in choosing their officers as well as candidates. That way, incessant internal rifts which always find their way to court will be reduced. If the constitution of a political party has prescribed duration for tenure of office of an officer, such officer should be humble enough to leave at the expiration of the tenure. In the final analysis, we found the appeal to be meritorious. The appeal is allowed. Parties shall bear their respective course. As the court will allow. That was the unanimous judgment of the court.
My noble Lord, we are very grateful for this judgment.
Thank you.
Thank you.